Good morning, everyone. My name is Becky Page with Human Resources of Plus, along with Teresa Frio, HRP's Senior HR Professional. We want to thank you so much for your time and attendance today. I know that time's actually becoming more and more precious, so we really appreciate you joining us today. Also, we're very excited to have a co-presenter today. We're pleased to introduce Jennifer Gokenbach. She is with the Workplace Council. She is a top-rated attorney in employment defense, and she has a vast experience in all industries. Jennifer's been a valuable strategic partner of HRP for many years. And during my portion, Jennifer may jump in to clarify some of my information. Both HRP and Workplace Council are very passionate about providing quality service and guidance to small businesses at affordable cost. Our webinar today is going to be moving around from the stay-at-home order to the safer-at-home order. Of course, that generated another significant amount of information, directives, and public health orders. So for those of you that are new with us, Human Resources' goal with these webinars is to take information, simplify it, and communicate the requirements in a way that is applicable in our clients' businesses. We have received many questions ahead of time that we put in the webinar. You are free to ask questions through the chat function. However, we probably will not be able to get to all of them. As you know, things are changing by the minute, so this presentation includes what we know as of today, Thursday, May 7th. Let's jump in and get started. So the housekeeping items is everybody is going to be muted. Make sure your video is turned off. You will receive a recording and a copy of the PowerPoint presentation. There are a lot of links in the PowerPoint where you'll be able to obtain more information. As I mentioned, you can ask questions in the chat window. We do value your time, so we're going to have a hard stop at 45 minutes. Again, all the information we know as of today. And as always, this information is not intended to be or provide legal advice. Our agenda today, we're going to talk about unemployment very quickly. We're going to do a very quick overview of the FFCRA. For those of you new with us, we've done 2 webinars on the FFCRA. If you're interested in getting the recordings and the PowerPoint, please email us at info@hrplusinc.com. We're going to talk about the changes to the Colorado Health Emergency Leave with Pay. This is a law that is state-specific about paid sick leave. We're going to overview the Colorado Public Health Order. We do have many attendees on the webinar from around the state. It's important that you understand that we're focusing on the Colorado State Public Health Order. However, many counties have their own public health order. So this is important when it comes to many areas, including mask requirements. So towards the end of the presentation, we have included links to many counties and their specific public health order. And then we're going to kind of wrap up with what's next. This is the most common question we've gotten in the last 2 weeks as people are getting ready to reopen. The question is, what if we call back a laid off employee and they do not return to work? If you have offered them their job back and they have turned it down, please report this to the Colorado Department of Unemployment. There is a link on their site, and we have a link in this PowerPoint, and it's called Report of Refusal of Suitable Work. This is a very new procedure for the Unemployment Department. This online form will require you to enter many details. So you want to have like your last day of work, the date you recalled them, the name of the person who made the recall, and details about the job. You want to do that as much as possible in writing, whether that be a formal letter or an email. Keep in mind the work in this title is called suitable. So even though you may have laid off an employee that was working full-time and you're calling them back for part-time, we encourage you to still complete this form. They may still be eligible for some unemployment, but it's important that the division knows some sort of job offer has been made and there has been a refusal. And just a reminder, with all submissions to the Unemployment Department, it has a process to go through. We strongly encourage you to continue to complete any form you receive from them. It's called a request for information, so they can make accurate decisions. And the ultimate decision on unemployment is always the division's call. So I know a lot of times employees ask employers about unemployment, but really they just need to defer to the Department of Unemployment. This next question is, I'm part of a vulnerable population that the governor has mandated to continue to stay home, but my employer wants me to come back. We will get into this a little bit further in depth, but with the recent Safer at Home order, no vulnerable individuals can be compelled by their employer to return to work if their work requires in-person work near others. They define vulnerable individuals as anyone who is over 65, individuals with chronic lung disease or moderate to severe asthma, individuals who have serious heart conditions, individuals who are immune compromised, pregnant women, and individuals determined to be high risk by a licensed healthcare professional are considered vulnerable. There is a link to the Safer at Home order, so you don't really need to worry about writing those down because you can get a link and they do specifically list those. So those are two of the biggest unemployment questions that we have received. We're going to just do a quick overview, like I said, of the FFCRA. Remember, it's in effect to December 31st. There's two parts to the actual act. There's the paid sick leave. It provides 80 hours for an employee that's unable to work or telework due to one of 6 qualifications. And then the Emergency Family Medical Leave Expansion Act, which provides job protection and paid leave for employers who can't work because of their minor's child school or child care service is closed. In the beginning, when the DOL came out, they told employers they would give them time to comply. As of April 20th, the DOL has announced the non-enforcement period has officially ended. They have made their first citation. It was to an electric company in Arizona, and they were ordered to compensate an employee who was denied this paid sick leave after he showed coronavirus symptoms and was told by a doctor to self-quarantine. We wanted to kind of just, for the Family Response Act, just kind of make it very simple. You know, you need to look at these 4 things. You need to have a poster, exempt resources, sorry about that, and tax credits. So for the poster, you want to make sure you posted the poster at your work site and or emailed the poster to your remote workers. If you're an employer that has employees reporting directly to work in different buildings, you do need to put the poster in each building. You don't need to send this poster to recently laid off employees. It's for current employees only. I know a lot of you are probably interested in this exempt. We've talked about it a couple times in our past webinars. If you are an employer under 50 employees, have you made the decision if you want to exempt your company from the number 5 qualification of the paid sick leave and the Emergency Family Medical Leave Act? So I want to make it very clear. If you have 1 employee, you are subject to all qualifications in the paid sick leave, with the exception of number 5, if you want to exempt yourself. The U.S. Department of Labor has given 3 criteria in which you can exempt yourself. There's no application process. It's very important you create this internal document, and very important you communicate it to your staff. The link's in there for question number 58 that covers it specifically. I do want to take this time to say, if you take the exemption, that there is a possibility of a risk, okay? If an employee files the claim and the DOL disagrees with your basis for asserting the exemption, you could end up having to pay not only the amounts owed, but also liquid damages and attorney fees. So not to say that you can't exempt yourself, but you want to have very factual and true and financial documents in your justification. Resources. Do you have a resources to call when you have questions? Do you have an HR consultant? Do you have an employment attorney? We're not all going to know it all, that's for sure. And you guys are busy, running, trying to get your businesses up and running, continuing your businesses. So strongly consider getting a resource where you can call with your specific questions. Also, we strongly consider, we want you to consider investing in onboarding technology. At the risk of sounding like a sales speech, it really is important. These posters, these acknowledgments, things like that, they are going to continue to increase. What an electronic boarding system is technically the employee file in an electronic system. They can access it through the computer, the phone. Let's say, for instance, you had a poster, you could upload it, send an email to employees, they can go in, acknowledge it, and sign it. So there's a lot of stress you have going on, and this is something that moving down in the future, really becoming involved in technology in your HR administration is going to help you a lot and definitely give you peace of mind. Remember, you get tax credits, and one of the important things is, do you have an appropriate leave request form that's going to satisfy the IRS guidelines when you submit your tax credits? For our members and clients, we do have these forms on our website under the COVID toolkit. Now let's jump into the Colorado Executive Order. So under this order, what it is directives. So the governor has given certain directives. So the first one, as we all know, those schools P through 12 were suspended in-person instruction. All vulnerable individuals have to stay at home except when necessary. Once again, those vulnerable individuals were the over 65 and the other list. Also, all individuals who are sick or who test positive for COVID to stay at home. I bolded this next one because it's very important, and this is where there's going to be a lot of questions, and we're all going to just kind of figure this out together. But it directs employers to accommodate workers with child care responsibilities and workers who live in the same household as a vulnerable person to the greatest extent possible by promoting telecommuting, other work options, flexible schedules, or other means. So it's directing you to do it. In all cases, I don't know that people would be able to do this, but we encourage you to try every resource possible to be able to accommodate these type of workers. In the order also, they advise Coloradoans to wear non-medical cloth face mask coverings, the nose and the mouth whenever in public. And once again, this is a device. Your specific your specific county order may have a different requirement. I think everybody's kind of seen on the news the different counties and cities that do require it, just not advise it. Prohibit public gatherings of 10 persons or more in both public places and private commercial. Also, beginning on May 4th, the non-critical and critical essentials seem to be kind of interchanged, used a lot to allow up to 50% of their employees to conduct in-person work that takes place outside of private residence in accordance with the mandatory social distancing requirements and protocol. So Jennifer, I do want to ask you, we did get a question on this. Let's say you're a small employer. They asked, they only have 9 employees. Do they have to do the 50% in their office?
Hi, can you hear me? I want to make sure I'm not messing this up technology-wise.
No, you sound great.
Okay, good. Yes, for right now, given the safer at home order and the directive from the governor, all businesses that are resuming work need to follow the 50% guideline, allowing only 50% of the workforce to come back to the physical workspace, and otherwise telework if possible.
Great, thanks. The other directive he gave was the Colorado Department of Labor to issue temporary rules to amend this Colorado health emergency leave. And Jennifer is going to do that portion. Right before I turn it over to Jennifer, and I'll let her kind of give a little bit more background on herself too, is another directive that I don't have on here is the governor gave a directive to the Civil Rights Division in issuance of guidance into how to avoid or prevent discrimination as it applies to COVID. And if we have enough time, we may touch on that area. That directive just came out this week. So I am going to turn over the presentation to Jennifer at this time. And we're going to talk about the Colorado Health Emergency with Pay.
Thank you, Becky, and good morning, everyone. Thank you very much for taking time to join our webinar and to participate with your fellow colleagues as well. So we look forward to answering your questions about the topics we're covering. Just to give you a little more background to me, I've been an employment lawyer practicing management side employment law for 17 years. I have my own practice. I used to be with firms until I decided to start my own business in 2012. So I have a lot of small business clients, and I'm very familiar with the ins and outs of running a business, as well as trying to comply with all of the various employment law rules and regs. So I'm going to jump right into the amendments that we have just seen come out, which were to the Colorado Emergency Leave with Pay. They're called the Colorado HELP Rules, that were put in place by the Colorado Department of Labor and Employment. The latest amendments were passed on April 27th, and they are going to be effective for at least 30 days, or as long as the state of disaster emergency by the governor is in place. They also have a provision that states they may only be in effect for up to 120 days, but we expect that that may easily be continued by just a new rule. So this is one that we want to just keep watching, because this has already been amended a couple of times since it was first effective on March 11th. So these new amendments that were just promulgated on April 27th include covering employees and providing paid sick leave for those employees that have flu-like symptoms or other respiratory illness symptoms who are being tested for COVID-19, or those employees who are under instructions from a healthcare provider to quarantine or isolate due to a risk of having COVID-19. The amendments that were passed on April 27th expand the industries that the Colorado HELP rules apply to. So as of April 27th, the newly covered employers in industries such as retail stores, real estate sales and leasing, offices and office work, elective dental and health services, and personal care services are all covered, in addition to the previously covered industries, which those previously covered industries, I'm going to pull up my list here, were leisure and hospitality, food services, child care, education at all levels, including related services such as cafeterias and transportation to, from, and on campuses, home health care, and nursing homes or community living facilities. One thing I did want to add to, with respect to the new industry covered under offices and office work, what that can be a little confusing, particularly for, say, a construction company whose primary industry is not just office work or otherwise other than construction. What this means is that those folks that work for that construction company that are working in an office location still need to be provided these Colorado HELP rules sick leave benefits. So for businesses that might expand multiple industries, those employees that you have that fall under the specific industry would be covered under these amended rules, not the entire company, only those folks that are working within these defined industries. So generally, this hasn't changed. These are just the general requirements of the Colorado sick leave benefits. It requires covered employers to provide up to 2 weeks, which is up to a maximum of 80 hours of paid sick leave at 2/3 the employee's regular rate of pay. If the employee does receive a negative test result before the end of the 2-week period, then the employer's obligations to provide paid leave would end. The 2 weeks are calendar days. So this means that it's different than the FFCRA in that the FFCRA leave can be taken intermittently to total up to 80 hours. Here, this is just a 2-week period. So if an employee is sick, for example, on May 1, the maximum that the Colorado employer has to provide is paid sick leave from May 1 to 14, that 2-week period, and then whatever hours that employee worked within that 2-week period, so, or would have worked. So that would be, for example, different for a full-time employee versus a part-time employee. They would get, the regular hours that they would have worked during that 2-week period if they're part-time. This next bullet is one that we're going to probably have questions about. The rules don't require an employer to offer additional days of paid sick leave if the employer already offers an amount of paid leave sufficient to comply with the 2 weeks. But if the employee's already exhausted their paid leave benefits, and then they have the flu-like symptoms, the respiratory illness, the COVID-19 symptoms, then the employer would have to provide these benefits in addition. So we wanted to go through some questions that we've already received about the Colorado HELP rules and what existed before and then the new amendments. The first question is, I have an employee that is experiencing COVID symptoms and does not have any company paid leave. Should I pay them the paid sick leave according to the Colorado HELP law or pay them according to the FFCRA? So here, if the company is covered under both laws, if they are both in a covered industry for the Colorado HELP rules and they're covered under the FFCRA, which here they would be because the COVID symptoms wouldn't be an exception for small business. The only exception would be the child care needs exception for a small business. So in that case, in the instance of somebody experiencing those, in my opinion, and I have to hesitate and say it that way just because these are such new rules and regulations and laws that we don't really have precedential authority, and we have to keep waiting for facts to come out from the agencies and amendments to be made and clarifications to be made. So right as it stands, in my opinion, if somebody has COVID symptoms, they would only need to to pay the benefits under the laws as they not consecutively, but as they coexist. So for example, here the FFCRA would provide more benefits than the Colorado HELP rules would in theory. And so if you're providing the 80 hours under the FFCRA, then you've satisfied your obligations under the Colorado HELP law. I think where it could get complicating is where we might have situations where somebody has been tested positive for COVID-19, resolved their symptoms, been symptom-free, and then maybe at some point in the future has another positive test. In that situation, the guidance right now is not clear if, for example, you've already paid or you've already accomplished the 80 hours of FFCRA leave and then simultaneously the Colorado HELP law rules. If that symptomatic employee were to 2 months later come down the road, we may have an amendment from the Department of Labor on this, but as of right now, I think that narrow circumstance of somebody being reinfected or resymptomatic could potentially require the employer to then provide the Colorado HELP rules leave at that later date, but not the FFCRA paid leave again. And I'm sorry if that's confusing, but that's a very narrow circumstance of somebody having this twice essentially. In that case, then I believe there would be exposure to the new HELP sick leave. And I would consult with your HR professional or your employment lawyer if that narrow situation were to occur. But otherwise, if they have it once and it's at the same time, you've satisfied both laws by providing the leave. The next question is, if the employee was only scheduled for 5 days during the 14 days they were off, how many days do we have to pay them? So under the Colorado HELP rules, if the employee was only scheduled for 5 days, for example, if they're part-time or if they had some other nuance with their schedule and that was when they were going to be working, then the employer's obligation is only to provide paid sick leave for the days in which they were scheduled, those 5 days. The third question is, can we require an employee to provide a doctor's note that they should be isolated or that they are being tested? So under the Colorado HELP rules, you can't require a doctor's note. You can certainly ask for a doctor's note. You can certainly ask for any sort of record from a testing facility or other provider. But the rules say that the employee is authorized to provide documentation at the end of their leave period. So they don't need to provide it up front. So they can provide documentation at the end. And if they aren't able to get a doctor's note, a testing facility record, anything along those lines, the rules allow the employee to provide a written statement explaining what their symptoms were, what medical testing, what medical advice they received, from whom, and then they can sign that written statement. And under the Colorado HELP rules, that's a sufficient type of documentation to support the need for this type of leave. So, you can't require the doctor's note, but it's certainly something you can ask for. And then if need be, you have to go that statement route in order to get the information that you need to justify the sick leave benefits that are being provided. And again, that doesn't need to be provided at the onset of the need for leave. The rules state that needs to be provided at the end of the leave period. The fourth question is, can I make my employee take their PTO before either paying the Colorado Help paid sick leave and the FFCRA paid sick leave? And the answer to that question is no. The FFCRA is expressly states that PTO need not be used, exhausted before those paid sick leave benefits kick in. So you need to be aware that these benefits need to be provided first to the extent an employer is covered under these laws before dipping into PTO banks. The next question is, does the Colorado Help Law apply to seasonal employees? And the answer to that is yes. It applies to any employee. They don't have to be employed for a certain period of time. They don't have to, be somebody, for example, like under the FMLA, where you have to have worked a set number of hours or been employed for a certain period of time. This applies to any employee, seasonal, part-time, newly hired, etc. The next question is, my industry was not covered under this law until April 27th. Do I have to go back and pay sick time? The answer to that question is no. When your industry became covered under the new amendments, that's when the employer obligations kicked in. Laws generally cannot go back in time and require you to do something. They're called ex post facto, and those are generally improper. So you can't be forced by the government to go back and do something before you were covered under the law. The next question is, how long is the law in effect? I touched on this at the beginning. The rules explicitly state that they are in effect for at least 30 days from the date that they're passed. So here, the latest amendments were passed on April 27th. So they are in effect at least until May 27th. But then the rules also state that it can be extended so long as the governor has declared a state of emergency, or up to a maximum of 120 days. But again, this is one of those to watch. It may be continued on beyond that maximum 120-day period. The last question is, I own a hair salon. Does this apply to my independent contractors? And the way that, to answer the question narrowly, no, this law does not apply to independent contractors. However, most of you who are familiar with independent contractors in Colorado know that that is not a simple test to determine whether somebody is properly classified as an independent contractor. And there are certain industries that are scrutinized by the Department of Labor with respect to their workers being properly employees or independent contractors. So just be aware that the designation of somebody as an independent contractor isn't always the end of the inquiry. If you have a question about that, you obviously don't want to deal with a challenge to somebody's independent contractor status and then deal with a wage claim as a result. So you may want to take a look at that, and not if you have any questions.
Great. Thanks so much, Jennifer. Like I said, she'll probably jump in on the next portion. Now we're going to move on to focusing on the public health order. And this, once again, is the state. So we're just going to do the highlights. There's a link in there. You guys can jump in and look at it. But they said that each workplace should identify a coordinator who will be responsible for addressing COVID issues. You need to maintain the 6-foot separation, clean and disinfect all high-touch areas, post signage for employees and customers on good hygiene, and ensure proper ventilation. Also, it's avoiding gatherings of more than 10 people. Eliminate or regularly clean and disinfect any items in common spaces, and implement symptom monitoring protocols. So we're going to get into temperatures and masks. I know we've had a lot of questions on that, so we'll be moving quickly into that. One thing I want to say is I think we've all, kind of been out to a store, and so we've kind of had the ability here, if you're just now reopening, to learn a little bit from the essential businesses that have been operating. So, you can take some of their ideas and, improve upon them or implement them. So big thing is, question we've had is, do I have to take my employee's temperature? The order says employers with under 50 employees do not have to take employees' temperature, but should complete an employee health screen form, which includes asking an employee if they have a temperature. The state provided a sample form, so you can get that sample form at the bottom. They say employers with 50 and over employees should take employees' temperature along with monitoring symptoms. Their recommendation is temperature checks as part of the screening is a touchless or infrared thermometer with an accuracy of plus minus 1% is recommended. So what is considered a temperature? We've gotten that a lot. The target temperature of concern is 100.4 Fahrenheit. Based on CDC guidance, employees with a temperature of 100.3 or lower may work. However, continued monitoring through the workday is recommended. As an employer, you can choose a lower number as a baseline temperature. Am I correct on that, Jennifer? I just want to verify that.
That I cannot answer right now.
Okay. Okay. I have seen some larger companies that had forms that was 99.9. Probably to be safe is to follow the 100.4 until there's clearer guidance. So face coverings, masks, which is a big thing. I think everybody's kind of seen it. So in the state order, it's required for employees when they're working in close proximity to coworkers or the public. And close proximity means routinely or consistently within 6 feet. Employers should make every effort to provide the face coverings, but employees should be permitted to provide their own. Kind of being devil's advocate as we do, if you are going to have employees permit their own, I suggest you have some sort of written policy that includes into your grooming policy, because you don't want people to come in with anything that may be offensive to other employees. So I'm just kind of looking at what challenges there are. So if you provide the face coverings, that will obviously eliminate that. Under certain conditions, employees may be able to avoid wearing a mask. Let's say they have their own private office, but when they get up to go to the restroom or past cubicles or things like that, they should be wearing a mask. Obviously, medical masks are required for the healthcare setting, including those in limited healthcare settings. This is where we've kind of listed, not all, but some of the public health orders, as everyone knows, in Denver, that effective yesterday, that you do have to wear masks when you enter into any post office, retail, any type of business. So I'm going to ask Jennifer a couple questions, because we've had questions around this. What if I have an employee who refuses to wear a mask?
Well, I just had this question yesterday from a client who actually called. They had a delivery driver who was home-based in Arapahoe County, but made deliveries within the city and county of Denver, and the employee was claiming that it was a constitutional violation for the employer to require him to wear a face mask because he didn't want to. Here, there are very limited exceptions to the orders, especially in the city and county of Denver, requiring a face covering. So the only exceptions in Denver's order are if somebody has a health condition that would, would impair their health if they were to be wearing a face mask. And that needs to be discussed and disclosed to the employer so that they can evaluate that. So essentially, if somebody is refusing to wear a mask and it is mandated by the county, in which the employee needs to travel or works, the employer can make a decision as to whether or not to continue that employee's employment if they continue to refuse, because otherwise the employer, at least in Denver, is facing a pretty hefty fine. For violations, each violation, it's a $999 fine. And so that's a legitimate, non-discriminatory reason to make a termination decision if somebody's refusing to comply with a government order like that, and exposing the employer to potential fines as well as other issues, that could arise if somebody's ill and not wearing the required face covering.
Great. And then we actually had another question where someone, a business that needs to go into other businesses, and where they have to go with the other business required anybody to enter the building to have their temperature taken. Business A goes into business B, so does business A's employees have to follow business B's rules, who's requiring to take temperatures, if that makes sense, hopefully?
Yes, it does make sense. And in my opinion, the employee of company A would need to comply with that because they're entering onto the private space of another company. And if that company has certain requirements of needing to record or test people's temperature, then they need to comply with that. If they have an issue, then they should bring that to the attention of their employer. The one, I guess, wrinkle would be, as a lawyer, I don't like the idea. I know some of the temperature testing devices actually physically touch somebody else, which makes me nervous as an attorney, just because if somebody's not authorizing you to touch them, even if it's with a object like a temperature device, you legally cannot touch that person. And so encouraging people, like in the governor's order, to use infrared devices, touchless devices. And then if there is an issue with physical touching of, testing things, hopefully that'll be brought up to the employer. And then if somebody has an objection to getting their temperature tested, brought up to their employer as well, so that they can get guidance and information about what's permitted and what's not.
Great. Well, it's bringing us to at the end of our webinar today. We really encourage everyone to establish protocols for all of this. The major sections are, administration, who's the coordinator, facility, safety, which is the cleaning, safe work practices, the physical distancing. On the slide prior, there are some counties that have some very specific physical distancing, so you don't have to recreate the wheel. Policy changes if there's remote work. Communicate at this point with your staff as much as you can. We do have sample protocol outline that's available to our members in the COVID toolkit. So kind of what's next is what I just talked about: communicating, strongly consider investing in technology, make sure you have a resource to call with questions, try to stay in the know as much as possible. Things are moving quickly, and we're here to support you and provide you, with as much information that you need. Big thing is just reassure your employees that their health is a priority if you're reopening, and we'll all kind of continue to get through this together. So Thank you so much for your time. If you're interested in any other information about Human Resources Plus or the Workplace Council, please free to email us at info@hrplusinc.com. Thank you again for attending, and hope we were able to answer some of your questions and clear up some confusion. And the last thing is please take care of yourself. Thank you so much. Have a great day.